Welcome everyone to the afternoon session. My name is Jonathan Rubin. I'm pleased to present the third panel today on net neutrality from the policymaker stakeholder perspective. So this has been an interesting couple of weeks for net neutrality. On November 10th, as everyone here knows, President Obama declared, "I believe the FCC should reclassify consumer broadband service," key phrase, under Title II of the Telecommunications Act, while at the same time forbearing from rate regulation and other provisions less relevant to broadband services to ensure, he said, that the network works for everyone, not just one or two companies. Comcast Executive Vice President David Cohen then wrote a blog post entitled, "Surprise, we agree with the President's principles on net neutrality. Free and open internet, they agree with that. No blocking, no throttling, increased transparency, no paid prioritization. We agree, and that is our practice," Mr. Cohen wrote. Just not as a Title II provider. So we've arrived at this juncture because of the limits of the FCC's legal authority that in January the DC Circuit Court made clear in its review of the 2010 Open Internet Order, specifically that the order ran afoul of Section 153(51), which limits common carrier treatment only for telecommunications services and not for information services. So the question is whether Title II reclassification is needed or able to correct that. For example, Section 202A of Title II prohibits telecommunications carriers from engaging in unjust or unreasonable discrimination in their practices, something we heard about this morning's panel. But the courts have interpreted this section in a way that's likely to permit certain paid prioritization agreements between broadband providers and content owners. There's a three-pronged test for determining unreasonable discrimination in violation of Section 202A. It requires a determination of whether the services at issue are like one another, and if so, whether there's a disparate pricing or treatment between the like services, and if so, whether the disparity is justified and therefore not unreasonable. Thus, where there's an underlying neutral, rational basis for the discrimination, it's likely to be permitted, even under Title II. Courts have approved the different prices and differentiated service levels, and some courts have also suggested that common carriers may be permitted to charge customers a premium for priority access to service without violating their common carrier duties. So even with reclassification, it's not certain that net neutrality would fall within the FCC's authority, even under Title II. So to help us solve this conundrum, we have four to be precise, very, very well-accomplished and true experts in this field. Our panelists are, in no particular order, Hal Singer. He's a principal at Economists Incorporated. Hal's also a senior fellow at the Progressive Policy Institute and an adjunct professor at Georgetown University's McDonough School of Business. He's a co-author of the ebook, The Need for Speed, Brookings, 2013, and the book Broadband in Europe, and has authored dozens of legal and economic articles. Dr. Singer has particular expertise in the media industry and has served as consultant and testifying expert for media companies such as Apple, AT&T, Google, Mid-Atlantic Sports Network, NFL Network, and, of course, the Tennis Channel. Dr. Singer earned his MA and PhD degrees in economics from the Johns Hopkins University after graduating from Tulane University. Next to me is Jonathan Jacob Nadler, also known as Jack. Jack is
Jonathan rule.
Well, you wanted all the names that begin with J anyway, but you didn't. You missed a couple. Jack is a partner at the newly consolidated firm of Squire Patton Boggs. He focuses on his practice on telecommunications and has extensive experience with issues related to the liberalization of regulation, the implementation of competitive safeguards, the regulation of IP-based services, and communications-related antitrust matters. Mr. Nadler has represented regulated wireline and wireless carriers, information service providers, whatever they are, computer and communications equipment manufacturers and large corporate users, and played an active role in the passage of the Telecommunications Act of 1996. I wondered who there was to blame for that, so now I know. And numerous Court of Appeals cases that followed. He also advises the state of Hawaii and has served as legal advisor to the governments of Singapore, Qatar, Hungary, Argentina, Bolivia, China, Costa Rica, Hong Kong, Peru, South Africa, and South Korea and Sweden. I wish I was your travel agent.
Don't forget Burma.
And Burma. Thank you. Regarding issues such as the introduction of competition in the telecommunications, media, and postal sectors, the licensing of new wireless entrants, and telecom issues in connection with the accession to the European Union. He's a graduate of Columbia University Law School and Vassar College. James Assay, Jr. is also with us. He's Executive Vice President of the National Cable and Telecommunications Association. As NCTA's second most senior executive, Mr. Assay is involved in all aspects of NCTA's work on behalf of the cable industry. He was formerly Senior Democratic Counsel to the U.S. Senate Committee on Commerce, Science and Transportation, and Telecommunications and Legislative Counsel for Senator Ernest F. Hollings. He's worked at Wilkie Farr Gallagher and served as law clerk for Judge Cameron Curry in the District of South Carolina, and has taught communications law as an adjunct at Georgetown Law School. Mr. Assay is a graduate of Georgetown University Law School and Stanford University. Nicholas Degani is wireline legal advisor to Commissioner Pei. Certainly, Pai. Thank you. Nick served as counsel to the House Committee on Energy and Commerce and to the Communications and Technology Subcommittee, where he focused on the Universal Service Fund, intercarrier compensation, privacy, cybersecurity, agency jurisdiction, spending, and the administrative process. He was also attorney advisor in the Wireline Competition Bureau Telecommunications Access Policy Division and worked in the Commission's Office of General Counsel in the Wireline Competition Policy Division. Mr. Degani served as a law clerk for Judge Jeffrey Sutton of the Sixth Circuit Court of Appeals, and he's a graduate of the Harvard Law School and Yale University, where he studied electrical engineering, computer science, and history.
Yes, sir.
Okay. So with that, I'd like to open up the panel with the following question. What does President Obama not understand about Title II that has caused him to make a pronouncement that he is in favor of Title II for consumer broadband services? And who'd ever like to go first? Let me just mention, if you do want to jump in on a comment or a question, make what I heard someone call a non-threatening gesture, and you'll be recognized. Jack, you want to?
I'll be happy to do it. I think with great respect for the President, the two things that I don't think he fully appreciates are, first, the challenge of reclassification of retail service. Indisputably, the service that an internet service provider provides to an end user is an information service, not a telecom service. Now, within that, there is a telecom component. Any reclassification would require a process to isolate the telecom component and apply Title II only to that. But the second and much more important thing that I think the President was not well advised about is that even if all internet access service were to be subject to Title II, I do not believe that the FCC would have the legal authority to ban all paid prioritization, which at the end of the day is the only reason people advocate the Title II solution, is because they believe that Title II, unlike Section 07, would allow for a complete FCC ban of the practice. The Title II prohibits unreasonable discrimination. I do not think that the FCC has the power to say that any arrangement entered into between an internet service provider and an edge provider, other than an agreement for a bill and keep agreement, an agreement for the delivery of traffic at no cost to the edge provider, that any other agreement is per se unjust, unreasonable, and unreasonably discriminatory.
Hal?
So I'll try not to pretend I'm a lawyer. I'm an economist, but I can repeat what lawyers say, and I will echo. I'll echo the sentiment that there really is no incremental protection against paid prioritization from Title II vis-a-vis Section 706. And in fact, if you doubt that correct statement, that you can just go look at what the Chairman Wheeler testified in front of Congress, I believe it was April of this year, saying exactly that you just cannot ban paid prioritization with the tools of Title II. So the flaw in the president's thinking, respectfully, is that he's not thinking like an economist. An economist would say, what are the incremental benefits of going from Title of 706 to Title II? It'd be, I want to get something at the margin, right? I want to get some goodies. And then on the downside is that you expose the economy and employees and consumers to the risk of less investment in the core of the network. That's the downside. Right? Now, some people are poo-pooing this in light of certain statements that various CFOs have made in the prior weeks. But I would just point you to the history of what certain dangerous Title II provisions have done with respect to cable investment in the late 1990s, with respect to telco investment in fiber in the early 2000s, with respect to CLEC investments. I actually have a paper published with Bob Crandall of Brookings on what unbundling restrictions or unbundling obligations did to competitive local exchange carriers with respect to investment. The problem, if I were his advisor, is I'd just say, look, at the margin, it just doesn't make sense in terms of the cost-benefit test. It fails a cost-benefit. We're going to risk investment at the core, and we're not going to get any incremental protection to go after paid priority. So why are you doing this?
Just to follow up on Hal's point, I actually have the quote here from Mr. Wheeler. He testified to the House of Representatives in May that, quote, there is nothing in Title II that prohibits paid prioritization. And in fact, if you go back in the 1890s, even there was a Supreme Court case about common carriage and the idea of having different classes of service and different rates. And it's really been very clear since then that common carriage allows fast lanes and slow lanes. That's just what the law is. So if that's the concern, Title II doesn't solve it.
So I would agree with what's been said. I think it highlights, from my perspective, this kind of disconnect between the ends and the means. You know, the president articulated, 4 principles: no blocking, no throttling, no fast lanes, and full transparency. And as best I can tell, there's pretty much wide agreement that those are the ends we seek. Those were the ends of the 2010 rules. Those are the ends which cable companies have followed and have invested, over $200 billion over the last decade in order to create an open internet experience. And where we seem to be getting wrapped around the axle is this assumption that there is only one means of doing that. And I would agree with my colleagues who say that the Title II means won't even get you to the professed ends that you want to achieve. But I think, as NCTA has been on record, there are ways of fulfilling those principles short of going down the Title II route, which involves a whole host of collateral damage, not just the effect on investment, but a whole lot of quite honestly imponderables that we sit here today and we have to ask ourselves. We've had this tremendous success in this country in building an internet that year over year gets stronger, faster, more deployed, and for the sake of correcting a legal case, we're willing to basically upset the entire apple cart and go down a different path. That's a mistake.
So you say correcting a legal case. I assume you're talking about the Verizon decision from January. Why is that case incorrect? What did the court get wrong?
Well, no, I'm not saying that the court got wrong, but the result of what the court said was it threw out the rules that were adopted in 2010, which, again, I don't know that the cable industry thought were necessary, but we were willing to abide by because we didn't intend to engage in any of the practices which were supposedly going to be prohibited. So if our goal is to basically reset and to try and go back to rules that the industry lived by, that, as far as I know, didn't lead to any major run on a large number of complaints or anything like that, it seems to me we have a much easier path that is fraught with a lot less dangerous consequences.
Let's maybe talk a little bit about the physical reality of the internet. In fact, avoiding prioritization across different types of applications, would you all agree that that's probably impossible as a technical matter?
I think we got into this some in the panel this morning. Really, the larger issue is services that allow for the rapid delivery of content. Paid prioritization is one. That concerns delivery in, if you will, the last mile. But there are other substitutes for that. There is direct interconnection, like the Comcast Netflix arrangement. There are content delivery networks like Akamai. All of these are different technological approaches that occur sort of physically in different places, all designed to speed up the time it takes from content to get from the edge provider to the end user. So if the FCC were to ban paid prioritization, as that's been understood, that is last mile paid prioritization, that would really not create this perfect level playing field, because entities that were willing to pay for direct interconnection, entities that were willing to host their content in a content delivery network server would continue to have an advantage over entities that were not willing or financially weren't able to do so. So unless you took the next step and said the FCC also should regulate or perhaps ban or direct interconnection, that the content delivery market should be regulated or banned, really there is no way to create this perfect level playing field that some people who are advocating the ban on paid prioritization think we have and think we must preserve.
Hal, you wanted to?
I don't think that proponents of strong net neutrality have a problem with prioritization. In fact, they acknowledge that it's needed and in fact exists all over the network. What they really get choked up on, no pun intended, is when it's paid and paid to an ISP. The concern, and this concern is articulated by Jonathan Baker, with whom I debated now twice on the issue, is that the ISPs are in a position to ask for excessive fees, and that's what animates the debate. And my response is, well, fine, if you're worried about the fees being excessive, then let's regulate the fees, but let's not set them at zero. That's probably not the optimal price.
Well, that leads to my next question, which is why I asked you about the technical feasibility. Is it your position, and by you I mean the plural you, and I'm looking for your reactions here, that paid prioritization, if it happens, would be the same under 706 regime as it would be under a Title II regime?
I can try to answer. I mean, it seems to me that per the Verizon decision, you can't do an adjudication regime one particular way for paid prioritization. Namely, you can't set the presumption that any deal is in violation of the standard and thereby place the burden on the ISP to come forward and on bended knee to some bureaucrat at the FCC and ask for permission to innovate. That you can't do. We know that from the Verizon decision. It's an open question as to whether or not you could set up the presumption that way under Title II. But what you could do under 706, and what I think the FCC was kind of moving towards until the political winds shifted, is you could flip the presumption around such that the initial burden would either be on the FCC or the complaining edge provider to establish that the agreement was in violation. I'll leave it at that.
Any other comments on the difference between paid prioritization under a 706 regime versus a Title II regime?
I mean, the only thing I'll add, and I find myself having to do this whenever the issue of paid prioritization comes up, is again, level set and say, we're talking about something that doesn't exist today. There are no ISP offers of paid prioritization. As far as I know, there are no plans because, quite frankly, I think ISPs do not believe that there is really a business there vis-a-vis providing capacity. So I think it's worth at least just reflecting on the fact that we're having an entirely a legal discussion that is divorced from the practical realities of the services that ISPs intend to offer, and that's perfectly fine. But I think we often talk about this as there's some clear and imminent danger that these prioritization services are being offered now, or are at the gate and about to be overrun with them, and that's just not the fact.
Let me understand what you're saying. You're saying that there's no paid prioritization, but you're not saying that there's no prioritization. Isn't that right?
I'm not aware of any services for prioritization that are being offered by a last mile ISP.
We heard this morning that VoIP services by their nature require greater throughput or smoother throughput than other types of services. Doesn't an ISP do that and do that for video as well?
Well, I guess I'm talking about the offer of priority over internet service. I mean, there's no question that with respect to other types of services, whether it's VoIP or cable service, there are quality assurance that goes in with the delivery of that service. But when we're talking about the offer of paid prioritization over broadband internet access service, I'm not aware of it.
Does everyone agree? I'd asked about whether or not it's technically possible, whether it's feasible to avoid prioritization within an ISP's network, and everybody sort of said not really, and now we're saying we're not doing it. So which way is it?
There's two different kinds. There's network, which falls over the rubric of network management prioritization. I mean, certain packets have to move faster than others just to make the damn thing work. And the FCC rules have always allowed so-called reasonable network management prioritization. That's different from saying, I'm going to prioritize you because I like your content, democratic packets go first, or I'm going to slow you down because you're providing a service that competes with an affiliate of mine, or I'm going to prioritize you because you're willing to put cash on the table.
Is that prioritization, or is that degrading everybody else and then charging money not to degrade someone?
Well, of course, the FCC NPRM proposal would find some standard to say, here is the baseline plain vanilla service that you have to offer with no charge. Now, if you want something better, you have to pay for it.
And outside of that paradigm is something else, which is the interconnection issue. And you had brought that up with respect to CDNs, Direct Connect, and that sort of thing. That's generally not considered a part of paid prioritization. Is that correct?
Right. I mean, the paid prioritization debate up until about 2 hours ago at the last panel really was a debate about last mile paid prioritization. But this is sort of, it's the perverse nature of this debate. We only came to Title II as an end run around the Verizon decision, and now while we're talking about Title II, well, we've got people like Cogent who are unhappy about a different problem, so maybe that's the solution to theirs as well. But no one mainstream in the net neutrality debate thinks that that's a debate about direct interconnection or about content delivery networks.
I do think they're separate, and I think that the chairman was correct a few months ago with his original instinct, which was to bifurcate the two issues and look at them. But I can find one thing in common, which is that again, what seems to concern folks, the way that I kind of assess the Comcast Netflix arrangement, is that both Comcast and Netflix kind of integrated into the middle portion of the networks, and the middleman, which was either Cogent or Level 3, was squeezed out of the equation. And the concern is, can we trust Comcast? I don't mean to pick on Comcast, but can we trust Comcast in setting the right price for interconnection? It's the same concern that we have about can we trust Comcast in setting the right price for paid prioritization on the last mile. So there is that component in common. I'll leave it at that.
There's less market power in the direct interconnection than there is in the last mile. I mean, by definition, if you're an edge provider, you are always dealing with a terminating monopolist. Whereas if you want to interconnect, I mean, I could see Netflix saying, well, gee, remember the iPhone when they came out, it was only AT&T. If Comcast is going to be unreasonable, we're going to do a deal with AT&T, and AT&T is going to go around, or Verizon is going to go around and advertise, we are the ISP that gives you fast access to Netflix. So I don't think the market power situations are the same, but That's
Do you
it.
mean Verizon Wireless? Because Verizon Fios is in, what, 15, 20%?
They're not in my building, and I live 2 miles from here, a mile from here.
Well, how does Verizon provide a substitute access to Netflix?
Yeah, I'm sorry, I said Verizon, I meant AT&T, really. I apologize.
We're also not.
Not here, but, you know, you have, I mean, usually you have at least the potential of at least 2 broadband providers in every market, whoever the second one is my only point. But can I go back to something that James said?
Absolutely.
You know, that panel this morning, they were really disagreeable, but that was kind of fun, and here we are all agreeing, and that's no good at all. So, you know, and besides, I'm sounding way more right-wing than I really am. I mean, my view is that there are legitimate reasons for proactive regulatory intervention. We have, at best, a duopoly market at the retail market. We have the situation of no matter how many retail providers there are, if you're an edge provider, you are always going to be dealing with a terminating monopolist. We've got a situation in which there is, under certain circumstances, certainly the ability and potentially incentives to discriminate. The internet is an important and powerful thing. So my view is it's not a delicate flower. The internet is not a delicate flower that has to be protected from every innovation, every change, every alternate arrangement, but at the same time, it is an important thing. There are limits in competition. There are real potentials for abuse, and so properly crafted prophylactic rules make a whole lot of sense in providing everyone, including the investment community, the regulatory certainty necessary to make informed business decisions.
I don't think. Maybe you were searching for disagreement, but I don't think I'm going to disagree with you. I think that I'm in favor of regulation here as well. I recognize that these vertically integrated cable providers might have the incentive to seek a higher price for, say, interconnection than would a middle mile independent provider. And for that reason, we should give them a close look. But the notion of whether or not we should proscribe entire classes of behavior out of these concerns, I think, goes a step too far.
James,
Yes, let me defend the honor of my vertically integrated cable companies, I guess.
Now it's getting fun.
Okay, let me
have it.
Right. I guess the way that I look at it is I don't see any evidence of that at all. In fact, I see quite the converse. The fact of the matter is you can say the ISP is a terminating access monopoly, but the market for interconnection is hyper-competitive. Many of these ISPs have multiple people that they do deals with, and if you don't want to, direct connect with Comcast, you can go find other folks who will deliver your traffic. And the fact of the matter is that the ISP entry into this marketplace has actually saved providers money. As if you look at the cost of transit over time, I mean, it's gone way down. So the fact of the matter is that companies and consumers are benefiting from the investments being made by ISPs as well as other parties, carriers that provide these services. So I don't see anything that leads me to believe that we are on the precipice of some market failure. In fact, I think we are adopting the strategy that is actually and under a regulatory regime that is promoting the investment we need and will continue to need for the internet to grow. And again, I don't, the cable industry does not have, and I'm going to put interconnection over here and go back to net neutrality. I don't necessarily believe that we're in the position where we say all rules are necessarily bad, but I think we do have to be very careful and recognize that the decision that was made on a bipartisan basis over the last decade to really refrain from government involvement in the decisions of how the internet works was a conscious choice that was made in reflecting regulatory humility and the fact that we could get it wrong, and we could get it very wrong, and the fact that we may not be able, through the regulatory process, to move as fast as the technology will want to evolve. So it would, I hesitate, and I think we ought to maintain that kind of healthy skepticism for government intervention.
Well, I think the point at which you started shaking your head in the no direction was when Jack said edge providers have to deal with terminating monopolists no matter what. And is that wrong? Why is that wrong?
Yeah, because I believe there are many different doorways into that ISP. There are multiple, the market for interconnection is highly competitive, and if
I
someone
think
can-
you misconstrued what I said. I agree with you on the direct interconnection issue, and as I said, I think that is and should be outside the debate. But in the situation of an end user, it is. I mean, if Nick is the customer and I'm the edge provider, and Nick pings me wanting my content, and you're his ISP, I have no choice at that point but to go through you in the last mile to get to him. So in that area, not in the interconnection, what I still think of as behind the switch, but in the last mile, you clearly are a terminating monopolist.
But I just think that runs counter to the, look, we're providing internet access service, and what that is a service that allows the consumer to go where they want to use whatever is out there on the lawfully on the internet. And it doesn't make our service any better to say, okay, we're going to provide access to everybody's content except your content. I think the reality of the situation is that our incentives are to create as valuable a product as we can for the American consumer, and that's what we see. We see constantly plowing new investment back into the service to provide faster speeds, and yes, these are scale businesses, and there aren't going to be 100 different ISPs out there, but I don't think we've risen to the level of seeing any kind of demonstrable harm from the fact that consumer service is definitely better than it was 5 years ago, and 5 years from hence it'll be better still.
Please, Nick.
So I just want to jump in with several of my disagreements with the panelists here, just to spice things up a little bit.
Thank you.
So first of all, the whole idea of the terminating access monopolist is really a Title II idea, because the idea of the terminating access monopolist arose in the idea of inter-carrier compensation. And it's because the government made back in, well, originally 1913 with Kingsbury, but really more later on in the 1930s, 40s, and 50s, a decision that said that local exchange carriers, so your local telephone company, could charge long-distance carriers on a permanent basis. I mean, this was originally was done by settlements. 1980s, after MCI was really on the scene, they moved to the permanent basis. But it basically said they could tariff charges that no one could dispute. So tariffs, for those who don't know much about them, these are the original contracts of adhesion. They are contracts where whether you realize there is a contract or not, whether you sign on the dotted line or not, if you happen to do something within the scope of the tariff, you have no recourse under state contract law, you have no recourse under federal contract law, and if the FCC or the relevant state commission, if it happens to be an intrastate tariff, has blessed it as being lawful, you have to pay the charges. Your recourse on a tariff is pretty much zero, which is very different than normal contract law where public policy and other things all come about. There's no pre-vetting of contracts. So if you want to just honestly talk about paid prioritization, if it were allowed to exist under either Title II or 706, the simple answer is under Title II, you could have tariffs, and you could force people to actually pay. That was the ultimate source also of the actual terminating access monopoly. It didn't matter how you delivered network to, say, Bell Atlantic. It didn't matter which node you went through. You had to pay the same price because they were given this legal terminating monopoly status and given the ability to charge you for it. That does not exist today online. In fact, as far as I know, neither the Congress nor the FCC has ever blessed the idea that ISPs could charge edge providers for paid prioritization. So I will tell you, having talked to several of the companies and the major commenters out there, they're actually more afraid of the FCC moving forward at all than not doing anything, because certainly under the NPRM that was proposed last May, some form of pay prioritization is inevitable, and that would be for the first time the federal government blessing the idea of pay prioritization, which I know many people, rightly or wrongly, find very, very scary. And this actually then also goes back to something that Hal said, which is that if we think the rates might be unreasonable, the government should be regulating them. You know, I will tell you, I tend to be very skeptical of government regulation. And based on conversations and the public statements of many ISPs that they do not currently offer pay prioritization, they have no plans to offer pay prioritization. In fact, it's very hard to figure out both technically how that would work and the business model. It seems to me, and I'm not sure the FCC itself could do this, but just a flat ban on pay prioritization makes a lot more sense than trying to come up with some wiggle room around allowing pay prioritization in these circumstances but not these other circumstances, which could either, you know, to the extent some of the people who are concerned about pay prioritization are right, allow pay prioritization out there and all the problems of the fast lanes. And on the other side, to the extent that ISPs or others come up with actual ways of doing it, traps them in the possibility of massive liability, especially if it's under Title II. And just to finish off that last point, here's another big issue with Title II. Title II has 201 of the Act, which basically says anything the FCC wants to think is unreasonable can be. And so just 2 months ago, the FCC said that it could impose a $9 billion forfeiture on a common carrier for violating reasonable practices. Not rules. We had no rules in place. And not one rule was cited in the NAL. But it said we could have imposed, and the company's name is Yortel, could have imposed $9 billion on them for violating what we thought were these ethereal practices. That's the kind of liability that, regardless of whether there's rate regulation, that's the kind of liability that comes with Title II of the Act.
Let me follow on the comment about it would be better just to ban it. Isn't that exactly what the DC Circuit said was not within the 706 authority?
I think that's right. I think that's also very clearly what's not within the scope of the FCC's Title II authority, which is precisely why back in January, back in February, back in May, this summer, my boss, Commissioner Paya, has repeatedly said, look, if there's a real problem here, Congress is by far the best place to resolve it. We don't have to get into these legal, gymnastics or whatever, what have you. I apologize, my brain's a little fried. We don't have to try to figure out some way to squeeze out a ban on pay prioritization at the FCC if Congress actually just steps up and does it themselves.
And
Congress can do
John,
a
can I-
ban as narrowly or as broadly as they want. I mean, they could tell the FCC full-scale rate regulation of pay prioritization services. But that, I mean, they're the ones who can do that. It's not the FCC.
And
that
without
has the authority.
legislation, there is no way, in your opinion, for the FCC to do an outright ban on paid prioritization. That's your...
Well, the NPRM specifically said there was no way to ban it under 706, and Chairman Wheeler testified to Congress that there was no way to do it under Title II. And if you look at the actual precedent, he's right.
So isn't a tariffed arrangement under Title II better than... Yes, Hal, if you could just answer this question. I mean, isn't a Title II arrangement as a second best alternative better than nothing?
No.
Why not?
Well, I mean, again, it would be the first time in history, to my knowledge, that the FCC or federal government would be blessing the idea of paid prioritization. And from the startups that I've talked to, that scares them like nothing else. And to the extent you think that tariffed anything is better, I would refer you to the last at least 30 years of our history, where tariffs have been a consistent and constant obstacle to consumer choice, to competition, and just an invitation to regulatory arbitrage.
I better give Hal a chance now before he...
Yeah, sorry, before your head explodes.
Oh, it's about to explode, because if I think what I heard you say, I think we now have a source of disagreement, respectfully. But if what you said was that you'd prefer just to ban it than to have it regulated, you're just absolutely wrong. From an economic perspective, the zero price associated with a ban is not the right price. And this is the unanimous opinion across the economic landscape. I want to give two templates of what I mean by regulation, because I think you may have interpreted that to mean a heavy-handed ex ante, we're going to dictate rates sort of regulation. And I want to first point you to how we treat program access complaints, which is if a cable operator vertically integrates into a must-have input like a regional sports network, we let that vertically integrated entity negotiate, right, with rival distributors. We don't step in and say that the price is going to be $3 per subscriber. We let them negotiate, right? It's only if at the end of that negotiation, one of the parties, typically the distributor, feels that the price isn't right, they can initiate a complaint, and then that complaint gets adjudicated by either an ALJ or AAA. So what I mean by regulation in that sense is, rather than say banning vertical integration into content, we allow the vertical integration. We recognize this newfound incentive to want to charge too high of a price, but we let the two parties negotiate with each other. The other template that I want to point to real quick is the Selco decision, which was cited about 20 times in the Verizon decision. And this is, in the DC Circuit's mind, what made it different from per se common carriage is you allowed the two parties to individually negotiate. Said it 100 times. So what would that mean is that we'd allow Netflix and Comcast to individually negotiate over interconnection rates, a la Selco, that's the data roaming, by the way. If one of the parties is upset by the final outcome of that negotiation, they can bring a complaint to the FCC, and the FCC would adjudicate it. So that's the kind of regulation that I'm talking about, this ex post, I would call it light touch regulation, but that clearly to me is better than proscribing an entire class of services or setting the rate at zero, which can't be the right answer in every situation.
There are some that say that, in fact, bill and keep as the dominant, if not exclusive, arrangement in the development of the internet so far is responsible for the democratic architecture of the internet, and that, in fact, what we're really discussing with net neutrality is a deviation or an abandonment of bill and keep. Do you agree or disagree with that? Jack?
I think the whole reason why we have direct interconnection, why we have content delivery networks is you remember in Jurassic Park, nature always finds a way? I mean, that's what this is. If you can't get faster access in the last mile, then you find another way to do it. So I really, yes, this would allow another way to do what every content provider wants to do, which is get their content to users quickly, and what a lot of users want. So I don't really see it as this great sea change.
Nick?
I mean, it's a little bit of a strange question. Bill and keep really is the regime that's been there. It will continue to be there, essentially, in the context of the internet, because the whole reason we didn't have bill and keep on the telephone side is because of tariffs and Title II.
But forbearance
precisely
eventually got us
because
to that, didn't they, in the
I'm sorry?
wireless? Doesn't forbearance get us to bill and keep basically in wireless at this point?
No, it's not. It's not forbearance that did it. It was a decision by the commission in the 2000s. I believe it was the T-Mobile decision that said that wireless was just not eligible to collect. It had nothing to do with forbearance at all.
And we would agree that avoiding intercarrier compensation and that kind of a regime is an important thing for the internet. Is everybody in agreement on that?
Well, I think avoiding any kind of, for me at least, avoiding tariffed access charges, the idea that people are not allowed to negotiate, but one side can just set a price that the other person has to pay, is a real problem. And that's a problem that Title II brings with it. That's a problem that Congressional Action or 706 does not bring with it. And that's very different than free market negotiations over how to interconnect or do other types of things. I mean, again, this whole concept of pay prioritization that was such an ethereal concept because, as James said, nobody is doing this. So I still don't even know what it would look like.
Right? Yeah. I'm kind of amazed, maybe amused as well, at sort of all the new friends that 706 has found. Now, the FCC went along for years and years, and I thought rightly, saying 706 was not a substantive grant of authority. They sort of had a deathbed conversion after the Comcast case and said, oh yes, it is got upheld. Now, everybody who is somewhat skeptical of net neutrality has suddenly embraced 706 as what they like. There's the flip argument is Title II, for whatever else you may say about it, there are a universe of tools there, and you can do this, 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 and this, and you can check them off as you go through the Communications Act, and you can either do them or you can forbear from them. 706, on the other hand, if the Verizon case is right, basically, the FCC can do more or less anything that it can, with 2 or 3 logical steps, say might someday drive investment in infrastructure. So I just find it interesting that people, I mean, in the old days, those of us that represented the old information service providers back when we wanted to be unregulated were very worried about Title I for exactly the same reason, because unlike Title II, it really doesn't have any limit.
They can do it as long as it doesn't look like common carrier rule.
Yeah, I mean, basically the DC Circuit said the FCC can use 706 to do everything it wants to, except for the one thing it most wants to do.
Right. I've been asked to see if there are any questions at this point. Yes, sir.
Thanks.
I figured.
I have a few questions. I just wanted to push back a little bit on paid prioritization from what I heard. I think I heard some panel members say that there weren't really any interesting business models or there's no reason to have it. But I think there are a couple right off the bat that it seems like prioritization would work for. One is video gaming. Downloading a video game over the internet now is pretty cumbersome. If I would bet you that there's value added to gamers and those companies that sell those games by willing to pay up for that. And on top of that, I don't think they want the house next door to be subsidizing. The house next door doesn't want to subsidize that type of downloading. And then right around the corner, we do have 4K TV. Netflix keeps talking about it, and sooner or later we're going to have 4K TVs in homes. And so again, if you have a world where there's growing appetite for that type of content, it seems like the lanes need to either be widened or priority needs to be paid. And on top of that, with prioritization, I think you do get increasing capital investment to meet those demands. So I'd like people to
Let's see what
comment on
the panel has
that.
to say about that. In particular, are we talking about paid prioritization within the network, or are we talking about interconnection when we talk about the potential problems of 4K video gaming, telemedicine, and the like?
I'll go. I think we could be talking about within the network. I mean, this is really a question that best put to an engineer, but from my understanding that some of these real-time applications that are sensitive to jitter and latency could benefit from priority within the last mile. And so yeah, I think it is foolish as a policy matter to start prescribing entire classes of contracts that may or may not come about 5 or 10 years into the future. We have no idea. Why do we want to outlaw them today?
So, look, as I said before, I think it's important that we distinguish between internet access service and other capacity on the network, which may be used for specialized purposes. There's no question that when you buy cable or satellite, television, you're buying a quality assured delivery service, and you're paying for that. When you're buying internet access service, you're buying a best efforts service. All I can do is repeat to you what the companies have told us, that they have not been approached by people who are trying to purchase that type of prioritized access over internet access service. And if you think about it, again, it goes to the nature and the value of what you are offering when you're offering internet access service. It might be great for a video gamer if all of a sudden all video game traffic were optimized over the internet, but that would suck for people who didn't care about video games and wanted to use it for somebody else. So you would have to get more value out of the niche of people who were seeking to pay for that type of access than the broad audience of people who gain value out of the generalized best efforts, access to do a host of other things. And it just seems like those incentives don't match up when it comes to internet access service.
Another question back, if that's all right, and then one here.
There was general agreement on the panel that the president probably didn't understand what he was asking for with Title II or the implications of what he was asking for. Chairman Wheeler certainly does. I'd love to hear your opinions on where you think Wheeler comes out in this whole debate.
Can I go? Well,
Go ahead. Sure.
oh, I think that he can't come out anywhere other than where the president went. His legs have been cut off. I mean, this is why the whole process has been tainted. There's nothing left for him to do, and that we're going to get Title II as a result.
You have the work. And so I would say, let's say do a thought experiment. Let's say the White House has now appointed all of you, and they said Title II are the marching orders. What problems do we have with forbearance? What sections of Title II would you have a problem with? Could it be done? What does your memo say when it goes back to the Oval Office?
Dear God, you're going to charge USF on internet, retail internet access.
So Universal Service Fund must be a part of any Title II regime over the internet, in your opinion?
Yeah, I mean, I think it's a very hard question about whether forbearance applies to universal service once you decide to define something as a telecom service.
Is it possible to forbear in a market where the FCC has not determined that there is a certain modicum of competition in order to justify the forbearance? In other words, can you forbear in a monopolized or almost monopolized market at all as a legal matter?
The short answer is it depends on what you're talking about. I mean, there are provisions of the Communications Act that have very little to do with competition. And so the presence or absence of competition really don't matter that much. I mean, for example, the FCC has repeatedly forborne from applying the facilities-based requirement of Section 214 of the Act to what are called now lifeline ETCs. And it did no kind of competitive analysis in those circumstances. On the other hand, for other types of regulation, whether it's rate regulation or unbundling, the Commission has said, well, these are requirements of the acts and requirements of our rules that are precisely about competition, and therefore, and this is all coming from the Quest Phoenix forbearance order, we are going to require in-depth studies on a very limited geographic basis of the substitutability of different services.
Well, I mean, the problem is that we've got this, I mean, terminating monopolists might be something out of common carrier law, but it's also something out of economics. I mean, they are a terminating monopolist in an economic sense, and so the question is it possible to use I mean, is the absence of competition is precisely what is motivating a lot of the pro-net neutrality folks to be pro-net neutrality.
Look, I have to, your premise is just wrong. I mean, the fact of the matter is, this market is workably competitive. I mean, there are at least 2 wired networks going into just about every home, and there are a host of wireless networks that continue to get better and better. So I don't think we need to assume the can opener that says we are in a monopoly environment.
So then forbearance does not run up against that particular problem, understood that that
No,
applies to competition-oriented statute.
But again, look, I think it runs up against the problem of we don't have a great track record with forbearance. I mean, Nick points to one example. Sure, it's a power that the commission can use, but I don't think you can divorce the question of how would you fix the collateral damage that Title II's application would solve. Why ask that question when you have been presented with by the court with this thing called Section 706 authority that we didn't think existed before, that now exists, that offers us a way of restoring the rules that got thrown out? What is the problem we are trying to solve for? And I think if you start from answering that question, you will be less inclined to go down the riskier route that has a lot more potential collateral damage associated with it.
I think we might have one more question from the group, if that's all right.
James, you said a few times that none of your members really have people coming to them looking for paid prioritization. I guess isn't the issue though not so much third parties trying to seek paid prioritization, but rather the ISPs favoring themselves over others? Somebody mentioned earlier AT&T slowing down Skype, and we've got these, let's just say, alleged slowdown of Netflix. I know it's a bit disputed, but clearly the cable companies have a video product, and Netflix is competing with that. So it's really prioritizing themselves over third parties.
I think the issue has always been the prioritization of certain bits over other bits over internet access service. The fact of the matter is, cable companies were in cable service long before there was an internet. So I don't think you can essentially eradicate the notion that people are not going to be able to provide priority or some quality assurance on other parts of capacity that have nothing to do with internet access service.
Quickly.
Oh. Well, the problem that is when you prescribe a class of behavior or contracts, you don't know who might initiate the conversation. It very well could be the edge provider initiating it in 3 years from now, the telemedicine guy knocking on the cable guy's door. The other thing that I wanted to point out is that I thought the May NPRM did this quite well. It actually suggested that the presumption for paid priority, and without knowing anything more, should be that it's fine until proven otherwise. But there was an exception, if you may or may not recall, with respect to exclusive priority. If there was an exclusive arrangement done, say, with an affiliate or with a preferred third-party provider, then that would be presumptively in violation of the commercially reasonable standard. And I think they got it exactly right, in that NPRM.
I'm afraid that's all the time we have for the panel. I'd like to thank our panel members very much for a very stimulating conversation, and we appreciate your time today.